Good morning or good afternoon, depending on where you are, and welcome to the second in our ESG webinar series. Today, what we're going to be talking about is ESG litigation risks, or as we put it, no good deed goes unpunished. And we welcome all of you here today. For those of you who are attorneys and might be wanting continuing legal education credit, we will be applying for CLE credit for today's webinar, and we will be following up with you via email to ensure that we have captured your bar admission information and the states in which you might be wanting CLE credit. Unfortunately, if you are in the state of South Carolina, we aren't going to be able to get CLE credit for you because South Carolina has a requirement that we have to inform them of the presentation 60 days in advance, and this webinar wasn't conceived within that time limit to be able to do that. So we apologize for our South Carolinian friends, but everyone else, we will be trying to get you CLE credit. My name is Allison Wood, and I am a partner in the Washington, D.C. office of McGuire Woods and in our environmental team, and my practice area is climate change. But for today's purposes, what you need to know about me is that I am the chair of the firm's ESG task force. We have a full service suite of ESG offerings and a wide capability to be able to help anyone and any company in their ESG journey, depending whether you're at the very, very beginning, wondering what is this ESG thing and what do I need to do, down to someone who's grappling with, whether and how to calculate Scope 3 emissions and report those. We are able to help. Today's webinar, as I said, is the second in a series of 4 webinars that we're putting together. You can see all 4 of them listed here and the dates that each will be taking place. If you missed the first one, which took place last Wednesday, you can always watch part 1 at this link that is provided below. And you can also register for parts 3 and 4 as well, if you would like. In case you're, furiously trying to think that you have to scribble down that link on the slides, no need to do that. After the webinar ends today, you will receive a copy of the slides by email. And so then you'll be able to get the link then. The other thing I want to cover is that for questions, if you have them, there is a function down on your screen where you can submit questions. If we have time at the end, we will go through those and talk through them. But if we don't, that doesn't mean your question isn't going to get answered. What it means is that you will get an email response from me or one of our other 2 speakers answering your questions. So we encourage you to ask those questions, and you will get an answer one way or the other. So let's talk about what we're going to be talking about today and who is going to be presenting. The first thing we're going to talk about are litigation basics and then also consumer protection actions. And that discussion is going to be led by Candace Blydenberg, who is a partner in our Richmond office. Then that will be followed by a discussion of specific enforcement risk that happens in the SEC realm that Lizzie Hogan, my partner in the Washington office, will be covering. And then I will be wrapping us up with takeaways for avoiding these litigation pitfalls and just wrapping up the presentation. And we will go from there. And with that, I am going to pass the baton to Candace, who is going to start talking about these litigation basics. Go ahead, Candace.
Thanks so much. Good morning, everybody. I'm going to try and advance. I will try and do 2 things, which is advance and talk at the same time. I may not be able to do that, but we will see how this works. I am a partner here in the Richmond office, or rather my house. And I thought we would go over just, again, as Allison said, the basics with regard to ESG and some trends that we've been seeing in the litigation in the cases over the last 5 to 7 years. I know that in the last webinar, the E part of ESG was talked about, but I thought we would, to make that last webinar, or who are new to ESG, we could just talk about what those letters stand for, and then we can go from there. So with regard to E, that captures energy, the energy efficiencies, carbon footprints, greenhouse gas emissions, deforestation, biodiversity, climate change, pollution mitigation, waste management, and water usage. And then the S is for standards and social justice, our wages and benefits, workplace and board diversity, community relations, privacy and data protection, health and safety, supply chain management, and other human capital and social justice issues. How corporations are governing energy and standards and social justice and structure, strategic sustainability, oversight and compliance, executive compensation, bribery, corruption, lobbying, and political contributions. And so now that we have, are on the same ground as to what we're talking about, the next question, maybe some of you are thinking, is why are we talking about ESG? Why are there articles and webinars and thought discussions like this in the legal space right now? And I think that the answer to that is threefold. The first is ESG disclosures, while voluntary, and still voluntary, were utilized initially as well as identifying opportunities of corporations. But now it's also a lever of value creation of stakeholders, consumers, and others measuring or trying to measure what a company values. The second perception of a corporate purpose. Up until 2019, most CEOs would state that a corporate purpose was to maximize dividends and money towards its shareholders. But in August of 2019, 181 CEOs of America's largest corporations changed that 22-year-old policy and defined a corporation's principal purpose as having a commitment to all of their stakeholders. The statement on the purpose of a corporation, which was adopted by the CEOs of the Business Roundtable, read in part that while each of our individual companies serve its own corporate purpose, we share a fundamental commitment to all of our stakeholders. And that purpose also involved those companies committing to, among other things, to deal fairly and ethically with suppliers, to respect the people in our communities, their communities, and to protect the environment by embracing sustainable practices and fostering diversity and inclusion. And the third is a populist movement that has been identified by individuals that have been in office, that has been recognized by consumer advocacy groups, and really is present in all of us because we are all doing this virtually. We all know that the advent of social media, there are individuals with a click of a keyboard that can make something go viral if they believe that a company has not done something or has done something that is contrary to their ESG statements. For example, not example of someone that's done anything bad, but example of statements recognizing this populist movement. Former Attorney General Loretta Lynch suggested, hold on, I think I got that, yes. Former Attorney General Loretta Lynch suggested in 2021 that companies were going to see scrutiny that went beyond the regulatory scrutiny to environmental justice, scrutiny that was going to go to racial inequality and ESG more broadly. And she also indicated that certain industries that may have been seen as contributors to systematic inequity may want to look at their role in undoing that inequity. And then the Public Citizen, which is a nonprofit consumer advocacy organization that's been around for a number of years. Not only did it draft a petition for rulemaking at the SEC that would create a standard disclosure framework for ESG, but it also characterized ESG's disclosures as ways to bring about accountability. And they also acknowledged that there is this populist movement to hold corporations accountable for bad actors. And so we have a populist movement, and we have a change in the perception of what a corporation's purpose is. And that tends to lead to litigation. So what types of litigation are we talking about? Of ESG litigation, but for the purposes of today, we thought we'd lump them into three big buckets. The first are secure derivative suits. Those are suits like Qualcomm and OC Data ESG litigation. They involved composition of boards of directors. They utilized statements about inclusion and diversity and brought lawsuits claiming breach of fiduciary duties because the boards weren't representing the companies, or the boards were not composed in ways that were the same as what the companies were identifying in terms of their desires for diversity. And the lawsuits failed. Courts in the federal district courts took a look at them under the Iqbal Twombly, and for those who aren't litigators, but it's a standard, and the federal courts where you could be a cause of action. And looking at it with using that standard, most of the federal courts said these are aspirational goals. These are puffery statements, and there's not any misrepresentation. There can't be much reliance on it. And so those cases have, for the most part, fallen by the wayside in the initial stages of an action. The second type are the SEC enforcement actions. I am in no way an SEC lawyer, and Liz is going to talk about those. But we have those that are on the rise as well in the ESG land. And the last, which I am going to talk about because I'm a tort lawyer, is a Consumer Protection Acts. And these are actions that are usually by attorney generals or purchasers of products or consumer advocacy groups. They are premised on the FTC green guidelines, but more of late, in the last 4 or 5 years, they are premised on the state consumer laws, consumer protection laws, or unfair trade practices. They're premised on the state laws because there is also a movement to keep this type of litigation in state court as opposed to federal court. The appeal of these actions, in addition to being in state court, is that the language in consumer protection acts and unlawful practices laws that are state bound or state laws usually involve very broad statutory language, prohibitions against representing goods or services of a particular standard or quality. Secondly, most states, in interpreting these consumer of favorability toward consumers, they're going to be liberally construed to the favor of a consumer. Third, these statutes also involve statutory damages for each violation. Allegation usually is made that every representation results in a violation. There are treble damages that are also contained within these statutory schemes. And lastly, attorney's fees and costs. And so you have what I call as a tort lawyer, an attractive nuisance for consumer advocacy groups. Jokes keep coming. But let's talk about 4 cases. There are a number of consumer protection have been filed over the last 10 years, and we don't have nearly the amount of time to go over all of them. But what I thought we could do is highlight 4 which show an evolution both of the claims as they have been presented in complaints by the plaintiffs, as well as the way in which they've been received by courts. The first I wanted to talk about is the Ruiz versus Darigold. It was a matter that was initially filed in the Northern District, and then it got transferred to the Western District of Washington. This case had involved plaintiffs who premised their allegations about Darigold making misrepresentations about how they treated workers and how they treated cows. This involves dairy associations. They premised it on a 2010 corporate social responsibility report that Darigold had issued. And I'm going to advance that so you can see that. The plaintiffs read the report and interpreted from that report that Darigold was treating workers fairly and treating their cows humanely. They then alleged that they relied on those statements when they chose to purchase Darigold products. But in 2014, they learned that workers at one of the Darigold member dairies had sued their employer for violations of Washington's wage and labor laws. And they also discovered that there were some questions that had been raised about the treatment of workers and animals at Darigold member facilities. So the plaintiffs alleged that they stopped buying Darigold products and that they would not have purchased Darigold products had Darigold been honest about the conditions in which the products had been created. The action was filed in 2014, and the gist of the complaint was that the 2010 report misled consumers into believing that all employees and workers were treated well and with respect and in full compliance with the law, and that every cow that contributed milk was healthy. The court, in reading the complaint and also in reading the report which was attached to the complaint, the court first acknowledged that the report was an altruistic publication, that Darigold didn't have to issue the report, but it did. And then the court took some time to look at the 60 pages of the report and identified that the plaintiff had only utilized 10 sentences or phrases within this 60-page report, and that was the basis of their complaint. And the court, in looking at those 10 sentences, said that, one, no one would interpret this report as making those representations if you looked at the entirety of the report and its purpose, as well as other language that was utilized in the report. Also, the report only dealt with 1 year's time, events in 1 year, which was 2009. So based on that, the court dismissed the initial action. As with anything with litigation, people adjust and change. And so we have a change in 2020 with the next case, which is Gardner versus Starkist. This case involved two sets of complaints, an amended complaint, a second amended complaint, and a denial by the court in federal court of a dismissal, both of the amended complaint and the second amended complaint. The plaintiffs in this case are purchasers of Starkist tuna, and they brought a class action alleging that the promises that tuna products of Starkist, being 100% dolphin safe and sustainably sourced, were false and misleading. So the plaintiffs in this case, learning, as plaintiffs bars do, decided to not just look at one report, but they looked at web pages, and they looked at labels, and they looked at press releases and cited to those in their complaint as evidence of marketing, that Starkist had undertaken a pervasive advertising campaign for a number of years for consumers to believe that its tuna was 100% dolphin safe. The second thing that the complaint did, well, the complaint also talked about fishing techniques that were used in the industry were dolphin safe, and fishing techniques that were used by others in the industry, which were known to involve some killing or harm to dolphins. And then the allegation was that Starkist was utilizing the latter, which would go against their claim that the tuna was 100% dolphin safe. The third was it alleged that consumers, more likely than not, would have bought Starkist tuna, or actually that consumers bought Starkist tuna because it was dolphin safe. And that if it hadn't been dolphin safe, they would never have made the purchases. Also lucky or blessed to be in, it depends on what hat you're wearing, in California, because the Ninth Circuit had recognized in a prior case that American consumers overwhelmingly would choose to purchase tuna that was labeled dolphin safe versus tuna that wasn't. So with that type of factual background, the court was faced with a motion to dismiss. And given that level of allegations, the court said, just right now, based on where we are, we're at the beginning of a case, the plaintiffs have sufficiently alleged fraud because the question is whether Starkist violated its own dolphin safe and sustainability promises. And to the plaintiffs and other consumers when it sourced its tuna in ways that it knew or should have known would kill or harm dolphins. The court also said that the plaintiffs had sufficiently alleged that the fishing techniques that are known in the industry to harm dolphins apparently were being utilized by Starkist, and so therefore their actions were not consistent with the words that they were putting out into social media and advertising for this tuna. And so the motion to dismiss was denied in 2019. A second motion to dismiss was filed in 2020, and that likewise was also denied because the court again said the case doesn't involve a reliance on what Starkist said. What this case is interpreting if Starkist is actually living up to its representations that it's putting out in the public area. And the court also said, at this stage, I cannot make a determination as to make that determination. That means that there's enough there for discovery to proceed, and therefore this case to continue. And so we've got more language and complaints that are being filed so that they can get past this initial anything. The plaintiff's bar changes up again and says, why are we in federal court? It's too difficult, too many motions. Why don't we go in state court? That's easier there. And if we stick with state protection laws that are broadly written, we can get past this initial wave of motions to dismiss. So the third case and the fourth case are state actions that have been filed recently. The third is Organic Consumers Association versus Tyson's Foods, and that's in the Superior Court of District of Columbia. This case is the plaintiffs are advocacy groups, Food and Water Watch Incorporated and Organic Consumers Association. And they allege that Tyson's was deceptive in its marketing by claiming that its chicken products were produced in an environmentally responsible way when it was not the case. The case initially was removed to federal court and then remanded back down to state court because the allegations were premised on the District of Columbia's Consumer Protection Procedures Act. That act was really broad. It defines a violation as representing goods that have a source or characteristics or use or quality that it doesn't. So a court taking a look at that and taking a look at the claim that Tyson had violated that act because it advertised its marketing, or it advertised and marketed its chicken as sustainable or used terms environmental stewardship or that it was protecting and respecting natural resources. The court in an 8-page opinion said, yeah, this goes forward. You know, they have alleged statements that Tyson's utilizes this. They allege that Tyson's is a polluter in the U.S. and routinely admits hazardous pollutants. They allege that they violated the CPPA, which is a Consumer Protection Procedures Act. They used statements from websites and corporate communications, and the court said, this isn't aspirational. There's enough here to make it actionable, and so the case will proceed into discovery. I'm running out of time, so I'm going to do this very quick. Are cases that are being filed recently against energy companies. In particular, have filed a number of or have filed Shell, ExxonMobil, BP, again, premised under state consumer protection acts. Claims are of deceptive practices and misrepresentations regarding the role of renewables in their business, or claims of misrepresentation about environmental benefits of fossil fuels. The complaints contain citations to websites, social media, including Twitter, Instagram, about customers that tend to buy products because they are environmentally sustainable or will do less harm. The remedy sought are injunctive relief and statutory penalties, court costs. Now see is that the ESG has moved into state courts, and it is using these statements, these voluntary disclosures, in measuring whether the actions of a company meet up with the statements that these fear. Last, as with anything, what's next? You know, the plaintiff's bar is always thinking, and I always say plaintiff's bar because of what I do, but and plaintiff's bar and purchasers and consumers, what's the next world? And that is environmental justice. There has been extraordinarily a large amount of activity in the EJ world, with states adopting acts and the EPA promoting environmental justice as a top priority, and even a contemplation of changing the name of Environmental and Natural Resources Division to Environmental Justice and Natural Resources Division. There is a regulatory move, and this combination of state consumer protection laws as well as EJ movement of trying to hold companies to their purpose of making sure all stakeholders are valued will continue to be attraction to those who want to use the good deeds that companies do in terms of putting out what they're doing in the world as opportunities for greater recoveries. I have happy to provide orders of all of these cases that we talked about. Just feel free to email, and thanks. Liz is next, and she's going to talk about the SEC, and I am going to advance the slides to her.
All right. Good morning. I'm Lizzie Hogan. I'm a partner in our Washington, D.C. office. I'm a co-chair of our securities enforcement and litigation team, which is a cross-office team, New York, D.C., you name it, Richmond, we're all over. But I'm here today. I'm going to speak about SEC enforcement risks stemming from the ESG space. So first off, if I can get this to work. Okay, talk a little bit about the evolution of the SEC ESG Focus. For more than 50 years, different groups have been advocating for SEC-mandated social and environmental disclosures. And the SEC, for the most part, has resisted it. And today we'll walk through a few of the key milestones to outline where this all started and how it's evolved over time, and really how we got to where we are today. So starting up with the slide that we have on the screen, this goes back to July of 1971. The SEC published its first environmental disclosure-related interpretive release, specifically suggesting that companies consider disclosing the financial impact, if material, of compliance with environmental laws. We'll get back to both of those key terms in a second, especially as we look at some of the scenarios that are cropping up today. A few years later, in April of '73, the disclosure suggestions were codified in the Form S-1 and the Form 10-K in connection with the National Environmental Policy Act. Fast forward to 2010, so a significant jump in time. The SEC issues guidance on climate-related disclosures, and this is one of the pieces that people point back to in trying to understand what's the SEC doing now while we're waiting for new rulemaking to come down. In 2012, looking back at the 2010 guidance, there was a GAO report that was issued that found that no no notable differences in both the pre-guidance and the post-guidance disclosures had occurred as a result of the guidance that was issued in 2010. And in fact, there was a review done in 2014, also looking back to this initial guidance. It looked at the S&P 500's issuers filings, and they found that despite an increase in climate reporting, that by more than 10 to 56% in that jump from 2009 to 2010, there was that big of an increase. However, companies were simply using boilerplate language with little discussion of material risks. Another leap forward to last year, in February of 2021, former acting chair Allison Lee of the SEC directs the Division of Corp Fin to enhance its focus on climate-related disclosures in public company filings. She instructed the staff to review and to update the SEC's 2010 interpretive guidance on the climate-related disclosures. And 550 or more public comments were submitted in response to this. 3 out of every 4 comments supported mandatory climate risk disclosure. And so obviously we know that there's more to come in this space as a result of all the comments that were shared. In March of 2021 last year, the director of exams, the new name for that division, announced that in exam priorities, there would be an increased focus on climate-related risks. Specifically, they outlined that they're going to be looking at business and continuity and disaster recovery plans. In particular, effective practices to improve responses to physical and market risks of climate change. Within the world of the registered investment advisors, a huge component that's under the oversight of the SEC, the alert observed that investor demand is driving socially responsible or sustainable investment strategies in the areas of open-end funds, ETFs, and qualified opportunity funds. As a result, exams shared that they would be reviewing the consistency and the adequacy of disclosures that the RIAs are providing to clients regarding those strategies. They would review fund advertising for false or misleading statements. And I have to make a plug that I know FINRA is also looking in this space, which is my former employer, where I was before I came back to private practice at McGuire Woods. The exams team is also looking to review proxy voting policies and procedures and votes to assess whether they align with the strategies as described. And then March of last year, there's a creation of the task force within enforcement to proactively identify ESG-related misconduct. This is a division-wide effort. There are 22 members in the task force today, or at least at the time of announcement. And with regard to the stand-up of the task force, they said that consistent with increasing investor focus on reliance and climate change and ESG-related disclosures and investments, the task force will develop initiatives to proactively identify ESG-related misconduct. Their efforts were initially focused, or going to be initially focused, on the identification of any material gaps or misstatements in issuers' disclosure of climate risks under existing rules. Again, that goes back to the basic standards of materiality, which we'll talk about, and the 2010 guidance that precedes anything that's under consideration today. As a result, they're going to analyze disclosure and compliance issues related to investment advisors and funds ESG strategies, as well as public companies. I can share from my prior experience running in an enforcement program in the securities space that you only create a task force when you already have a stable of cases and investigations in the pipeline. And the effort there is really to consolidate the focus and into a core team, and that helps inform uniform application of the rules, uniform exploration of the different topics and strategies and theories of liability. That means that there's already work that's underway that maybe we haven't seen quite yet, and I'll talk about sort of the tea leaves. You can read on that a little bit, but it also helps the front office at the SEC prioritize those resources to decide where they want to move first, if they have a good concrete landscape in front of them of the various cases that are within that task force. So then we move to July. with Chairman Gensler in office at the time, and he now here, and he directs the SEC staff to develop a mandatory climate risk disclosure proposal by the end of 2021. Well, we're in 2022, and we know that hasn't come out quite yet. But as we talked about last week, my colleagues who really focus on the rulemakings in this space, we do expect it to be coming pretty soon. And then September of last year, the SEC released a sample comment letter requesting information about material climate change-related transition, litigation, and physical risks, the purchase or sale of carbon credits or offsets, indirect consequences of climate-related regulation or business trends, and why a company's SEC filings contain fewer disclosures than its corporate social responsibility reports. And I know Katie spoke about that a lot last week. Again, if you missed it, good opportunity to go back to the link that Allison pointed out to catch up on the material she shared on that space. So to speak about current SEC enforcement activity, there isn't a ton in the recent period because a lot of it has to go back to the existing rule book as we wait for the new disclosures and requirements to come down, which are, of course, going to be subject to a lot of review and it's going to take time. But that doesn't mean that they're not already focused on these issues. It's just through the lens of the original framework. So enforcement activity in this space really hinges on material misrepresentations. The analysis, therefore, centers on that definition of the core principle of materiality, and that is a substantial likelihood that a reasonable investor would attach importance to the information in determining whether to buy or to sell a security or when making a voting decision. It does not include information about that a specific investor might consider important, and today, the enforcement activity is making clear that the SEC views the concepts embedded within the ESG umbrella as material to investors. And I think as more cases come in this space, we'll be seeing the test of how far they're intending to take that. So I'm going to walk through a few cases, some of which have been resolved, other of which we've heard snippets from in the press that haven't been fully resolved and settled, and so there aren't a ton of disclosures about them, but we'll speak about a few to try to give some color as to the direction in this space. The first one I'm going to mention is a settlement with Fiat. It involves an emissions settlement concerning their disclosures related to compliance with environmental regulations. This is a 2020 case. Fiat was ordered to pay the SEC $9.5 million to end a dispute about their emissions disclosures after the SEC found that it had made misleading disclosures about an internal audit of its emissions control systems. Specifically, the SEC had alleged that in February of 2016, Fiat had issued a press release and its annual report with misleading information about its environmental compliance status. Fiat had represented that it had conducted an internal audit that confirmed its vehicles complied with environmental regulations concerning emissions. The SEC alleged that Fiat's statement did not sufficiently disclose that its internal audit was limited in scope and that it wasn't a comprehensive review of the company's compliance with U.S. emissions regulations. Instead, that internal audit focused only on whether U.S. sold diesel vehicles contained an emissions defeat device. In other words, hardware or software that interferes with or disables emissions controls under real-world driving conditions, or whether it had used any other method to skew emission test results. Rather than disclose its internal audit was limited in that way to examining for a defeat device in diesel vehicles just in the U.S., Fiat represented in its press release and the annual report that year that the audit had concluded that all current production vehicle calibrations are compliant with applicable regulations and that they appear to operate in the same way on the road as they do in the laboratory under the same operating conditions. At the time, the EPA and the California Air Resources Board had expressed concerns that Fiat might be using the defeat devices to cheat the emissions test. I have to note that Fiat neither admitted nor denied the allegations in the terms of the settlement. But it's interesting to point this out, not only for the SEC enforcement risk. Here, internal materials not being consistent with public filings and press releases, that this settlement also follows a very well-known diesel emissions case and investigations where another car manufacturer was found to have used software to bypass the emissions test. And of course, that also resulted in significant securities shareholder litigation as well. So moving on about disclosures involving climate change, in May of last year, Under Armour resolved a case with the SEC in which it was accused of failing to disclose known uncertainties concerning its future revenue prospects. So the SEC here, the order particularly noted that Under Armour's senior management understood the negative impact of warmer weather due to climate change on the sales of the higher-priced cold weather apparel. Under Armour was alleged to have engaged in what is called a pull-forward sales practice in order to meet its revenue targets. The order alleged that during 6 consecutive quarters, starting in the third quarter of 2015, again, a lot of this activity goes back a long ways, Under Armour had accelerated $408 million worth of existing orders that customers had requested to be shipped in future quarters and accelerated them forward. This practice caused the company to offer incentives to wholesale customers, including discounts, extended payment terms. Pulling forward is essentially at odds with standard accounting practices, which is why it has the SEC's focus. The SEC found that Under Armour had failed to disclose the source of that revenue growth, and that the orders were pulled forward, and instead suggested that the growth was caused by other factors. They also failed to disclose the implications of that pull-forward practice, including serious doubt as to whether the company could meet its future revenue projections. While it wasn't the driver of the allegations against Under Armour, the SEC order particularly noted that the senior management understood the warmer weather impact on the sales of their cold weather apparel. And so while they were penalized for not disclosing specifically the pull forward practices, that climate-related commentary in the SEC's press release and the order simply explain where they thought what they thought was driving the company's action to engage in this accounting practice because of the climate risk it had presented to its revenue streams. After the SEC's proposed rules on climate disclosures are unveiled and tested and enacted eventually, you can imagine how this type of climate impact on business operations could factor into and strengthen a case against a public company that is adjusting its accounting practices to address climate impact on sales and without adequately presenting those operational risks in your required public filings. Ultimately, Under Armour, by the way, resolved the matter for a settlement for $9 million on that one. Very recently, we've heard word out of the Dallas-Fort Worth office of the SEC. We understand that they have launched a probe into ESG disclosures of banks that act as underwriters in Texas. Texas recently enacted 2 new laws banning state entities from working with companies that discriminate against gun makers and fossil fuel companies. The Fort Worth office is requesting that banks substantiate their ESG policies as outlined in their public disclosures and scrutinize potential conflicts between what banks have communicated to their investors who are sometimes seeking ESG-friendly directions and policies versus the Texas regulators. Under the Texas law, lenders who desire to underwrite offerings of securities offered by or issued by local and state governments in Texas, they must sign public certifications stating that they do not have a practice, policy, or directive to boycott energy companies or discriminate against firearm entities or trade associations. A number of financial institutions have filed these certifications. And these lenders have also publicly committed, in some instances, to reduce their carbon footprints and achieve net zero greenhouse gas emissions by 2050. The SEC is most likely concerned whether companies are making one set of representations to their investors and another, potentially contradictory set of representations to the state of Texas. I'm going to try to fix my camera really quickly. Okay, maybe that's better. I could just see it zoomed out to get the full conference room that I'm alone in, thanks to COVID. All right, moving on. We also have word of an SEC probe into an asset manager's sustainability claims. The Wall Street Journal broke a story that the SEC has launched a probe into a European asset manager's arm of an international financial institution over claims that the asset management branch overstated how much it used sustainable investing criteria to manage its assets. Typically, we don't hear about the enforcement division's activity until charges are filed or a settlement's been reached, unless there's information that gets leaked to the press or there's an action taken by the staff that requires disclosure by a public company in its public filings. Here we have the former. In this case, there was a whistleblower. It's a former employee, and it's actually the former chief sustainability officer of the financial institution that told the Wall Street Journal that the asset manager had misled investors by misrepresenting and overstating its use of sustainable investment criteria. Specifically, that the firm had represented that more than half of its $900 billion in managed assets were invested using a system in which companies are graded based on ESG criteria. According to the firm documents, strategies were ESG integrated if they were actively managed and they included coverage of ESG criteria in more than 90% of the portfolio. The firm has denied the allegations, noting there's a distinction between ESG integrated strategies and ESG dedicated assets under management, and they're drawing a distinction between those two groups. This matter will be a very important one for funds and asset managers to watch, as more firms are focused on the classifications and the international standards being applied in order to make adequate or accurate disclosures about how their funds are being managed. I'll note also in this one, this isn't just the SEC. The DOJ also has a probe into this. And as we've seen recently with congressional requests to bring in executives from oil companies up to Capitol Hill in the near future, and just we're at the end of last year, this isn't going to be an SEC-only focus. There's going to be consistent congressional oversight in this space and activity as well, and obviously the Justice Department is equally engaged on this. And then looking at workplace practices, there's an SEC investigation concerning workplace practices, sexual harassment and discrimination claims that came up last year. Activision has disclosed in its public filings that it's in receipt of an SEC subpoena. According to the filing, the SEC will test Activision's public statements against internal statements. They're going to evaluate those statements against the impact on the market from subsequent disclosures of government and civil lawsuits. The staff has requested minutes from the board meetings, personnel files of former employees that are involved in the claims, separation agreements between the company and the staff, and communications among senior executives regarding the complaints from the employees or the contractors. All of these need to be analyzed through the lens of a traditional disclosure analysis, right? And what this case tells us is also that companies need to be exercising caution when you're coordinating with HR also about the disclosures being made. This isn't just about operational risk and accounting practices, but this extends to your employee base as well. And when whistleblower complaints arise, it's similar to how whistleblower claims have been treated and throughout the SEC enforcement legacy here and all the cases that have been brought in that vein, with thorough investigation and careful consideration of those complaints and addressing it properly through the traditional corporate governance structures. So where will enforcement go next? As I mentioned, the task force no doubt has a number of investigations in flight, but it can be many months, sometimes years before those land at a place or resolve in a manner that are brought up to the public through a settlement document or a charge being filed. So one of the ways we read the tea leaves is to look at what the exam process is doing. And very helpfully in this front, the exams division released a risk alert specific to ESG investing in April of last year. It describes their observations of both poor and effective practices used by investment advisors regarding green funds. The staff will continue to evaluate whether firms are accurately disclosing their ESG investing approaches and have adopted and implemented policies, procedures, practices that are accord with their ESG-related disclosure. Some areas of interest that they highlight. Oh, before we get to that, I'll mention them and then I'll turn to the poor examples. The areas of interest to them, and again, this is really focused more on investment advisors rather than the public company side of this, but I think it's a very active space for the SEC. They're going to be looking at portfolio management, performance advertising and marketing, as well as compliance programs. So some of the examples of poor policies and practices observed by the staff in this risk alert, they found that the portfolio management practices were inconsistent with the ESG disclosures. So there was a lack of adherence to global ESG frameworks to which firms claimed adherence. Again, this goes to which standards are being employed. And I think we can expect to see more as additional guidance and rulemaking comes down about what the expectations are and to try to find some uniform way of comparing apples to apples in this space. They also found that fund holdings were predominated by issuers with low ESG scores, which was inconsistent with what the firm's stated approach were for these particular funds. They also found inadequate controls in ESG investing. There was weaknesses in the policies and procedures about the implementation and monitoring about the clients or the fund's ESG-related directives. For example, monitoring of a client's negative screens, tracking and updating those, client preferences not being effectuated because of challenges with implementation or monitoring them, despite contrary market claims. They also found inadequate disclosures controls in the ESG disclosure and marketing process. So not adhering to the global frameworks. I'm trying to speed up to give Allison some time to speak at the end of this. Having unsubstantiated claims regarding investment practices, lack of documentation for the ESG investing decisions, and having the paper in the file is always better. We know that. Failures to update your marketing materials in a timely manner. So if it's documented, there are opportunities to revisit it, especially as portfolios shift or things are changed in that regard. They also hit on proxy voting, that public statements about ESG proxy proposals would be independently evaluated on a case-by-case basis, but the internal guidelines didn't provide for that. Clients weren't provided with an opportunity to vote separately on ESG-related proxy proposals. They have identified some potentially misleading claims and some ineffective compliance programs. Happy to share more on that, but I want to hit a couple of the good practices before we run out of time. So effective disclosures. It's your friend. Katie spent a lot of this about the risks that need to be considered as companies are reviewing their filings for the upcoming year. Clear and precise and tailored to firms' specific approaches to ESG investing that are aligned with the firm's actual practices. Look to simple and clear disclosures regarding firms' approaches to investing, including the factors that could be considered alongside many others. Explanations about how investments were evaluated using the goals established under their frameworks, under those international or global standard frameworks. Importantly, policies and procedures that address ESG investing and those that covered the key aspects of the firm's practices there. And last, it's the value of people. Having compliance personnel that are knowledgeable about the firm's ESG-related practices and that communication between the different groups within the firm that are responsible for both marketing and for public filings and disclosures to make sure a consistent and accurate theme is being provided. With that, I will turn it back to Allison to give us some thoughts as we wrap up.
Thanks, Lizzie. That was great. And I have plenty of time. Don't worry. So I'm going to now wrap us up and talk about, well, what are the takeaways that we can glean from what Candace and Lizzie have told us. And honestly, I think it can really be boiled down into a simple number one rule to avoid these types of pitfalls. And that is simply that your actions have to match your words, and that whenever there is a mismatch between what you are doing and what you say you are doing, you then are running a big risk that litigation of the types that we've talked about today could come your way. And so when we talk about words and a company's words, this doesn't mean this is broad. This can mean, what are your employees saying at a conference? What is your CEO saying on an investor call? What do your tweets say? What does your Facebook page say? What's in your corporate sustainability report? What is on your website? So think broadly when you think words, and make sure that what you're doing matches. Breaking that down into some more simple rules just to sort of think about that, pulling from the prior presentations. If you promise something to your customers, then you need to deliver it. Otherwise, you're running a litigation risk. So, for example, if you talk about how you treat cows ethically or chickens ethically, then you need to document that you're actually doing that. If you say that your tuna is dolphin safe and sustainably sourced, then it needs to be dolphin safe and sustainably sourced. If you talk about your oil products reducing greenhouse gases, you need to be able to document that that's true. So, keep that in mind. If you know about something material, then you need to honestly disclose it in your disclosure statement. So, for example, if you know that the warming weather is going to have an impact on your sales of cold weather gear, then you need to disclose that in your SEC filings. If you say that you've done an internal audit of the emissions control systems on your products, then you need to have done that internal audit before you say that you've done that. Your public statements also have to match what is happening inside your company. And here is something that I very commonly see. What is public facing and what is internal aren't matching up. So, for example, if you talk publicly about how your company makes investments, then your actual investments need to match that approach. There can't be a mismatch there. If you talk about how you look for sustainable investments, then the actual investments you're making, you need to show that they are sustainable. If you talk about that you adhere to some type of global ESG framework, then you need to follow that framework. If you're not, you're running a huge litigation risk. If you claim that your company does something, so for example, you talk about the fact that when you're looking for new directors, you are searching for diverse directors, or you talk about the fact that, again, if you're making an investment, that you're looking for ESG investments, then your internal policy and procedure documents need to direct that activity. So in other words, it needs to say, in some type of policy or procedure, we actively do the following things, or you must do the following things, to locate a diverse director, or you must take the following steps to make a sustainable investment. Equally important, if you are no longer doing something or offering something, then your marketing materials need to be kept up to date and reflect that. And some companies have gotten in trouble, for example, where they had had offered ESG funds, and that fund is no longer available, but it's still up on their website, and it looks as though it's available when it's not. So your statements also can't be potentially misleading. So really avoid any type of puffery when you're thinking about anything having to do with ESG. Be really careful when you use words like green or sustainable, and be able to answer the question of what are the data or the criteria that you are using to make sure that, in fact, this is green or sustainable, that there is some type of basis on which you're making that statement. Make sure the left hand and the right hand know what they're doing, that all areas of your company are coordinated. What different leaders say have to match. And then finally, think about your political spending. This is something that a lot of people haven't been thinking about. Where you give your dollars shouldn't conflict with what your ESG commitments are, or that can also be potentially problematic. So again, the number one rule is that your actions have to match your words in this space. And if you keep that in mind, that will help avoid a lot of these pitfalls. For those who may not have been here at the very beginning, I'm going to reiterate that if you are an attorney, we will be seeking continuing legal education credit, and you will be followed up via email on that. So look out for that. Also previewing a week from today is going to be part 3 of this webinar series, ESG and the Global Financial Markets. And, please register for that. That webinar is going to be led by my partners, Mark Nadu and also Penny Zacharias, and it's going to be great. So be ready for that next week. If you have any questions about anything ESG related, please feel free to email or call me, and I will connect you with the right expert within the firm to help you. And with that, we're done. And if you submitted a question that we couldn't get to, we will be following up with you by email. Thank you.